Welcome. Supporters of driver's license suspensions argue that a driver's license is a privilege and that if you do not pay your child support, then the state could revoke your license. The critics of driver's license suspension state that, well, if you take the driver's license, then you cut off the ability for that father, which they call obligor, uh, to earn an income. Well, this issue was decided by the case called Kavadas versus Department of Motor Vehicle in New Jersey. It was argued by the law firm David Perry Davis. In the decision of this case, Judge Mary Jacobson's opinion, which is 187 pages, stated that the automatic suspension of driver's privileges violates the due process as well as the fundamental fairness. And she further, in her opinion, states that New Jersey should provide a process in which to eliminate this practice within the next 120 days. And if there are any fathers who are caught in this process of driver's license suspension, New Jersey must provide them, one, an opportunity to be noticed, and two, they should provide legal counsel. Here is the letter that started this process. It has the Governor Christie on it in New Jersey, and Michelle Miller, who is the acting director over by the right side of the letter, and Raymond Martinez is the Department of Motor Vehicle Commissioner. Next is the letter that shows as of April 1st, 2019, New Jersey no longer practices what is called the automatic suspension of driver's license as a result of non-payment of child support. This time, Ms. Michelle Miller is now the director. Hello, my name is Chris, and on this channel, we show that the child support process violates your rights, and we provide suggestions and tips for you to fight those rights. In this case, we will review the Kavadas versus DMV. On this channel, we provide education on legal writings, both public and private, decisions, case laws. We review statutes and regulations. We also provide templates. This is our non-lawyer maxim. As we've said on our channel in many of our videos, that the practice of law cannot be licensed by the state. And in this example of NAACP versus Buttons, a non-lawyer can actually assist individual or group with their court cases. What we're saying is, on this channel, we provide you with education regarding the law. We're not your lawyer. We just provide education that you could use in your child support case. At the end of this presentation, we have what is called a call to action, where we provide you tips and suggestions. If you are one of those fathers who are trapped within both the DMV process and the child support process. So let's begin. Let's review the case. The suspension of license in general, its statute is 22 CFR 5170. Basically outlines the procedures for revocation of license. The Department of Motor Vehicle does not have what is called immunity from a lawsuit. Again, they're an agency of the state. Enforcement and suspensions of license. It also falls under another section of the statute called Section 466A16, as well as 42 USC 666 of the Social Security Act. Here, it outlines the details. First, all 50 states should have what is called an administrative or statutory process for the suspension, restriction, or revoking of license. Each state imposes its own triggering criteria. That is, at what point do you issue the process or start the process for suspension of license due to failure to pay or not paying child support. Next, this affects all professional license, occupational license, recreational license, as well as passport. While this process is in place, due process of rights must be included. Let's look at New Jersey itself and the statute. As the federal regulation says, it is a statutory requirement within the state. On the screen, there is New Jersey, and the public law for New Jersey is 2A17-56.41. It is a judicial process, and here are the requirements. After 6 months of non-payment of child support or arrears, they start a suspension process. They give you 30 days notice in a certified mail and give you 30 days in which to challenge that. On the screen, there is New Hampshire, which is also an administrative process. In New York, that's a judicial process. We have said here on this channel and many places, you need to know which jurisdiction you are in. Are you in Article 1 or are you in an Article 3 court? It's important because you have to argue your case appropriately. If you would like the remainder, or if you have questions about your state, please feel free to reach out to us, send us an email, and we can let you know what the requirements are for your state. Next, we review this statute, 45 CFR 264.30. In it, it says, state agency must refer all appropriate individuals in the family of a child for whom paternity has not been established or for whom child support orders are established, and that information will be sent to the Child Support Enforcement Agency, which is called a Title 4D agency. It is our opinion on this channel that every male is in this database, and we'll talk more about it. But if you want to understand your rights or defend your rights, if you want to defend against this statute, please review our video called Defend My Rights. So let's look closely at the case. Let's do a review. On the right side, here's the docket, which is MER-L-1004-15, which is 2015. And it's Superior Court of New Jersey, and it's a civil action. The plaintiffs in the case is Kavadas, but Kavadas is joined by Grabowski and Dancing. Those are the plaintiffs. The defendants are Raymond Martinez, who's the chief administrator for the Department of Motor Vehicle. Another defendant is the Attorney General for New York. More defendants, the administrator for the Department of Health, where the Office of Child Support Enforcement is managed out of. That's important. They included the Department of Health as the defendant. They also added the Director of Administrative Office for the courts. So to summarize what the judge is saying in her 187 page, which is a small book, when there's a delinquency or there's a non-payment, the state of New Jersey rushes to revoke the license. But even though the statute asks for due process, those due process claims are valid because they weren't followed. It was based on a ruling called Pasqua versus Council of 2006, where in that decision, Justice Barry Albin says, in addition to challenging the Department of Motor Vehicle, attorneys that the DMV or the state or the Office of Child Support must provide an attorney access, or at least access to legal counsel while they're fighting this process. Here's why we are excited about this case. It's called a good faith and credit. The United States Supreme Court says that an issue or a case that's settled by a court in one state must be recognized by the courts of other states and may not be reopened. Later, Chief Justice John Marshall suggested that the judgment of one state must be recognized by other state courts as final. That's Abelman versus Booth. And where a higher court have stated or made a decision within the federal courts, then all states must abide by that ruling. That is Howlett versus Rose. And as always, all federal laws are applicable to every state. That's Bullock versus United States. So here is why we're excited about this. This case was settled in New Jersey. That translates to you could use the details of this case within your state. That is all 50 states. And the argument is you could use the example of Abelman versus Booth to prove that. We're saying that this is your golden ticket, your blueprint in which to challenge the suspension of your license. Now, I will caution, you can't just run out and just make copies of this document, put a letter together and run to the courts or to DMV and says, here, it says my license due process and I should have my license back. It's a little more involved than that. And for the rest of this presentation, we will cover some of the things that you need to include in your case. Next, let's do a critical analysis of the DMV policy, as was shown within the Kavadas lawsuit. In New Jersey, there are about 66,000, what they call fathers who defaulted on their payments, which resulted in their license being suspended. Of that number, about 400 or so were able to get what is called a hearing on the matter. That's 0.57, not even 1% were allowed a hearing. In addition, they discovered that New Jersey DMV was charging $100 to restore those driver's licenses. In 2015, the DMV made $7.5 million from this process alone. What it basically states that everyone who's involved in child support have recognized child support is a money grab, has always been a money grab. It was designed as a money grab program. Again, that's our opinion. And we refer to the Supreme Court case, Blessing versus Freestone, where the justices came to the conclusion that child support Title 4D program has nothing to do with your child, the mother, or the father. It has to do with compensation between the states, federal government, and their agencies. This case, Kavadas, proves of one of those entities that it is a money grab program. Next, there's a case within the process, a gentleman by the name of James, who was caught up in this revocation process within Essex County. It was discovered that his license was revoked as a result of the child support. His process for undoing a mistake, again, it was a mistake. It took forever. Likewise, others have caught up in this process where they were issued summons. Some were even arrested because they did not know their license was suspended. On average, within New Jersey, about 400 erroneous suspensions per year. That's about one per day. So let's take a look at the brief itself. We've decided to take some pieces of it that we think you should know for your child support case, as well as for everyone should know. First exhibit, the private interest. You have a private right to the information on your license. Yes, the Department of Motor Vehicle owns your driver's license. However, the information that's contained is your personal information. If you want to know your rights, we have a video called Know Your Rights. You want to exercise those rights, please review that video. Next exhibit. The plaintiff included a chart, which is on the screen here, of where whites and non-whites between the years 2010 to 2014, they showed that the practice had a discriminatory elements to it. Now, one would argue, how did you know that? Well, we all know that the driver's license contained your race, your eye color, your hair color, your height. You could track it. So in this case, they presented that more times than is believed that non-whites were targeted, separate from whites. So that, again, helped their case. Next exhibit they included was the Department of Justice letter. We have a video on this channel where we take the Department of Justice letter and show you that there's at least 5 lawsuits within that letter. The Department of Motor Vehicle is the number 1 lawsuit, and here we're reviewing the Kavadas case from that letter. So let's review the 45 CFR 264.30 as we stated earlier. We believe that the state agency provide all mails or send all mail information into the Child Support Title 4D database. And the reason for that is in the Kavadas case, there were folks who got caught in the program who did not have an order for child support and did not have a child involved. The question is, how did they get caught in a program that's designed only for child support? It means that their names were inside the database. Again, this is our opinion. So now this brings us to a section which we call call to action. And here's where we suggest the things that you could do if you are in this process for suspension of your driver's license. The first thing you need to get is Department of Justice letter. You can also get the deprivation of rights letter, which in another video we show you how to get that, how to complete that. Next, you need to get all the documents for your court case. You need to understand when and how the trigger for your suspension of license. With that information, you will, if you decide to do so, prepare or draft a motion or petition asking the DMV to demonstrate and prove the due process before revoking your license. If for any reason you require an attorney to do that, again, the judge argued that you can request an attorney. As to whether you get one or not, that's entirely up to you. You could do this without an attorney. Again, you have a choice to argue your case. If for any reason you need help on this issue or you just need more information about this Kavadas case, please feel free to reach out to us. As always, you can always email us with your comments or questions or any suggestions that you have. We also ask for a small donation or gift to help us and assist us in our research, where we take the time to review cases appropriate and relevant for the folks who are involved or may not be involved with the child support process. And we're asking for us $25 or anything, any amount thereof. We also ask you to subscribe and please share the video, especially this video, to everyone and anyone so they can understand how the Department of Motor Vehicle has been making a significant amount of money as a result of the child support process. So this is the end of our presentation, and we want to thank you. On the screen, we have links to other videos. Goodbye.